Okay, guys, welcome back. This is your lesson for Tuesday, April 14th. We're going to finish up the judicial branch today because you have a test coming later this week. So let's go ahead and dive in. So first thing, the early Supreme Court, the early federal court system lacks weight, dignity, and respect. And that's tied to a whole bunch of different things. Maybe chief among them is that they didn't have a permanent home until 1935. Up until 1935, the Supreme Court actually met in what's called the Old Senate Chamber. They didn't have a permanent home where they kind of had their own building, and it was very clear that the judicial branch carried the same weight, carried the same level of respect and dignity and importance as the executive branch and the legislative branch. So when you don't even have your own home, it's really hard to claim that you are of equal importance. Similarly, another reason that the judicial branch is looked at as kind of the least of the three for part of American history has to do with judges riding the circuit. So federal judges were required to make an appearance in all federal circuits. So that means they are spending their year traveling the country, showing up in each of these 11 different circuit courts, rather than being kind of centrally located in a home base. When the Supreme Court is functioning much the same way that a traveling salesman or a circus functions, in that it kind of rides in and out of town, it's really hard to also insist that it is of equal importance to the executive branch and the legislative branch. And really, the Supreme Court was a stepping stone job. It was a stepping stone job to either run for president, to serve in a president's cabinet as one of the secretaries, maybe Secretary of State, Secretary of Defense, something like that. It was being a Supreme Court justice was a job that you took in order to push you into that elite tier as either the president of the United States, run for president, cabinet secretary, maybe a U.S. ambassador, things like that. But that changes with Marbury v. Madison. Marbury v. Madison, as you might remember from earlier in the school year, is a result of some of the fallout from the presidential election of 1800. In that election, Thomas Jefferson is a Democratic Republican, and he is running against the incumbent. The incumbent in that election is Federalist John Adams, and essentially what ends up happening is Marbury sues James Madison. James Madison is a cabinet secretary for President Jefferson, who wins the election, and Marbury sues because he was appointed as a federal judge. He was given a federal judicial position, not as a Supreme Court justice, but as a federal judge. He was by John Adams after Adams lost the election, but before Jefferson was sworn in. So Adams knew that he was leaving office. He knew that Jefferson had won the election, and he decided that he was going to appoint a bunch of his friends to federal judicial positions on his way out. Well, ends up there's some clerical errors, there's some paperwork errors, and when Jefferson takes office, Marbury still hasn't risen to his post. He still hasn't taken that job as a federal judge, and Jefferson simply refuses to confirm him, essentially to follow through on Adams' appointment. So Marbury sues. He wants his job. He wants the job he was promised by Adams. So he sues James Madison. James Madison's role in this entire thing is going to be critical because he is the incoming Secretary of State. So he is kind of the chief figure in the Jefferson White House. Marbury looks at it and says fairly simply, listen, President Adams, he promised me a job, right? He appointed me to this federal judge position. There's a contract. There's a paper that says that I am supposed to be a federal judge moving forward. And Madison says, yeah, you're right. President Adams did, in fact, promise you that, but I don't work for President Adams. I'm not here to carry out the work of President Adams. And frankly, I'm not here to fulfill the promises of President Adams. I'm here to work for President Jefferson. I'm the Secretary of State for President Jefferson. And yeah, I'm sorry about your luck, man. I don't know what to tell you, but you're kind of on your own on this one. Marbury fires back and says, well, I don't care whether you want to enforce it or not. That really isn't my point. I don't care if you work for President Adams. I don't care if you work for President Jefferson. You work in the executive branch. And the Judiciary Act of 1789, in Marbury's opinion, according to Marbury, which this is correct, says that the Supreme Court is able to issue what's called a writ of mandamus. Now, a writ of mandamus essentially is a court order from the judicial branch to either the executive or the legislative branch, telling them that they have to do something, right? So the Judiciary Act of 1789 says that the Supreme Court can force another branch to do something. And Marbury says, listen, because that piece exists in the Judiciary Act of 1789, you don't have a choice. You have to give me the job. Madison, as Secretary of State, fires back and says, well, we have this whole thing of separation of powers, and the Supreme Court can't make President Jefferson do anything. That is entirely outside of their parameters. Ultimately, this is going to land in front of Chief Justice John Marshall. John Marshall, probably our first significant Chief Justice, our first significant Supreme Court justice of any kind, has a decision to make. Should Marbury be appointed to the federal court or not? And really, it comes down to this. If Marbury wins, if he gives Marbury the position as a federal judge, he has absolutely started a power struggle with the president. He has started a power struggle and a major conflict between the executive and the judicial branch. And if Madison wins, the Supreme Court looks extremely weak, right? It makes the Supreme Court look like they kind of just fall to the wishes of the president at any given moment. So he wants to try to kind of thread the needle between those two. Ultimately, what he says is that the biggest issue here is that part of the Judiciary Act of 1789, the part that talks about the Supreme Court issuing a writ of mandamus, that portion of the act is unconstitutional. The Supreme Court shouldn't have the power to issue writs of mandamus, and as such, that's kind of the decision made by the Marshall Court. Obviously, Jefferson and Madison are thrilled by this decision, and it introduces this concept of judicial review. We've defined judicial review earlier in the school year, but just as a refresher, judicial review is the power of the courts to determine whether acts of Congress and the president are constitutional. Are laws made by Congress, are executive orders signed by the president, are they constitutional? Are they in line with the U.S. Constitution, or is there a contradiction or a conflict or a violation there? Ultimately, Marshall's decision in Marbury v. Madison establishes the judicial doctrine of judicial review moving forward. Judicial review is going to come to be wildly significant in a whole bunch of different cases that we've talked about since, right? Whether it's Brown v. Board of Education, Mapp v. Ohio, Miranda, Gideon, Engel, Tinker, all of the ones that you see on your screen here, judicial review is going to play a part in all of them. Another significant moment from judicial branch history, President Franklin Roosevelt is pictured here on your screen as part of his effort and his New Deal to get America out of the Great Depression. He established all kinds of different government agencies, all kinds of different government organizations and administrations in an effort to provide job opportunities, to provide financial relief, to save the banks and farmers and this whole wide range of a legislative agenda to bring America out of the Great Depression. And he was frustrated because over and over again, the Supreme Court was looking at some of these agencies he created. He was looking at some of the things he was asking these agencies to do, and the Supreme Court was deciding that either these agencies weren't constitutional, or that the things that they were being given power to do were unconstitutional. And so they were dismantling them. They were basically, in a lot of different cases, telling President Roosevelt, like, listen, I understand that you're trying to help, that you're trying to pull the country out of the Great Depression, but you can't just establish an agency that starts passing out money left and right in all of these different circumstances. All of the things that you do as president have to abide by the Constitution. They have to be constitutional. And Roosevelt says, all right, that's fine. If that's the way you're going to go about it, here's what I'm going to propose. I'm going to propose that we increase the number of justices in the Supreme Court, right? Because I can't remove Supreme Court justices. Once somebody is appointed and confirmed to the Supreme Court, they are there for life. So I can't get the people that are there to change their mind. But as President of the United States, what I can do is I can increase the number of people that are on the Supreme Court. I can change that number from 9 to, say, 31 if I want. And if I have 31 justices on the Supreme Court, that means I get to appoint 22 more, because there's only 9 of you right now. And if I appoint 22 more justices, guess what? They're all going to agree with me. And you're going to stop finding all of my agencies, all of my administrations, all of these organizations. You're going to stop telling me that they're unconstitutional. If Roosevelt has his way and is able to change the number of Supreme Court justices. This is frequently referred to as the court packing plan. Basically, Roosevelt was trying to change the rules of the game when it comes to the Supreme Court in order to get ahead, or in order to kind of have some flexibility with his agenda legislatively and politically. Ultimately, obviously, it doesn't work out. The number of justices stays at 9, and all of those things, that Roosevelt was working towards are going to kind of fall by the wayside if they're found unconstitutional. All right, next piece, and this is going to be really critical: the difference between judicial activism and judicial restraint. Over and over again, we've talked about the decisions of the Supreme Court, and we've talked about some of the unique rulings that they've made. This was particularly common earlier in the school year when we talked about civil rights and civil liberties. Okay, so let's define them first. Judicial restraint is an approach to decision making in which judges play minimal policy-making roles and defer to legislatures whenever possible. As you see pictured there at the bottom is Justice Antonin Scalia. Antonin Scalia is an infamously big proponent of judicial restraint. He does not want the court to be making policy. All he wants the court to do is interpret the Constitution. That's it. Interpret the law. Apply the Constitution as originally constructed. Do not be responsible for making policy. That's the job of the legislative branch, not the job of the judicial branch. On the other end of the spectrum, you have judicial activism, an approach to decision-making in which judges sometimes make bold policy decisions, even charting new constitutional grounds. Chief Justice Earl Warren is kind of a good example of that. He's responsible for a lot of the civil liberties cases that we talked about earlier in the year when we talked about things like Tinker or Engel. All of these different civil liberties cases are really largely in line with the Warren Court and Warren's preference for judicial activism. So to quote Chief Justice John Roberts, a judge's job is to call balls and strikes. We do not pitch or bat. This is an extremely good example, or an extremely good quote to kind of reflect the idea of judicial restraint. It's not the judicial branch's role or responsibility to be an active participant in policymaking. Rather, they are supposed to act with restraint. They are supposed to simply interpret what is in front of them, interpret what they're given, not be an active participant in it. Cartoon, absolutely. This cartoon here, I think, is pretty fascinating because it is critical of judicial activism in that really, is it the role of the judicial branch to establish policy? The cartoonist obviously would say no, that the Supreme Court is not supposed to take the place of the legislative branch in any situations at all. They aren't supposed to establish policy. They are, again, simply meant to interpret the Constitution, to interpret the law, and make rulings based on constitutionality. They are not supposed to make policy decisions. Here's Chief Justice Earl Warren again, and we talked about this earlier, but the Mapp decision, Miranda, Gideon, Engel, Tinker, and Griswold, those are all really good examples from the Warren Court of judicial activism, right? If you think about specifically, I don't know, let's pick Griswold v. Connecticut, and it's a conversation about contraceptives in Connecticut and being sold in the state of Connecticut, and whether or not you have a constitutional right to privacy. Well, that's a pretty big step. That's a bold step from the court to decide that that a right to privacy is implied in the Griswold case, or that it is implied in the Bill of Rights as it applies to the Griswold case. A justice that is exercising judicial restraint would say, well, no, you don't have a right to privacy because we don't see it in the Constitution, and we don't think it's our decision to tell the state of Connecticut whether or not they have the authority to ban contraceptives. That's just not our place. You see Thurgood Marshall, Justice Thurgood Marshall here. He views the Constitution as a living document. He's absolutely a loose constructionist, and typically people that are loose constructionists are also big fans of judicial activism. Strict constructionists or originalists are often people that are big fans of judicial restraint, but Marshall absolutely is synonymous with judicial activism and loose constructionism. I referenced the Griswold case earlier. Again, the Griswold case is a really good example. This is not the Griswold case. This is the predecessor to the Griswold case, whose name is eluding me at the moment. But again, the Supreme Court stepping in and deciding that a birth control law is going to be nullified is a really good example of judicial activism. That's the Supreme Court essentially telling a legislature that their rule is either okay or not. All right. You see President George W. Bush here on the screen, and he famously said that the American people he'd promised the American people to seek judges that would faithfully interpret the Constitution and not use the courts to invent laws or dictate social policy. Right? He was pretty focused on making sure that he appointed people to the Supreme Court that were going to utilize and lean on judicial restraint rather than judicial activism. All right, let's talk about judicial restraint and judicial activism as they apply to one in particular case, and I think Obergefell v. Hodges is probably the right case to have this conversation with regard to. Again, Obergefell v. Hodges is a Supreme Court case deciding on the constitutionality of same-sex marriage, right? And in this case, Justice Anthony Kennedy, famously kind of the swing vote in this particular case, said that no longer may this liberty be denied to them. Same-sex couples ask for equal dignity in the eyes of the law. The Constitution grants them that right. It's a perfect example of judicial activism, right? It's a perfect example of the Supreme Court stepping in and making a policy decision. And Kennedy famously took some heat for that opinion. Justice Scalia, in the same conversation, or in the same case rather, said today's decree says that the rule of 320 million Americans coast to coast is a majority of the lawyers on the Supreme Court. The opinion is the furthest extension one can imagine of the court's claimed power to create liberties that the Constitution and its amendments neglect to mention. He looks at the decision in Obergefell v. Hodges and says, this is ridiculous. Like, I can't possibly fathom why my fellow justices on the Supreme Court think it's okay for us to decide that same-sex marriage is legal. We are establishing a law for all intents and purposes, and that isn't our job. That's the job of the legislative branch. So this quote is, again, a really good example of judicial restraint. Chief Justice John Roberts, who is typically a little bit more moderate justice, and he's kind of all over the map, but he says this court is not a legislature, and our Constitution does not enact any theory of marriage. In this particular case, in the Obergefell case, he absolutely demonstrates judicial restraint, saying that it is not the place of the judicial branch to make policy, to essentially create laws for the country. The interesting piece is that in the Obergefell case, Chief Justice John Roberts exhibits judicial restraint, and that's pretty odd because just a couple years prior to that, in NFIB versus Sibelius, he gives one of his more infamous decisions. As you might remember, NFIB versus Sibelius is the Supreme Court case having to do with the Affordable Care Act, and specifically the question as to whether or not the government can mandate its citizens to have health insurance. And in that particular case, Roberts says that the framers created a federal government of limited powers and assigned to this court the duty of enforcing those limits. The court does so today, but the court does not express an opinion on the wisdom of the Affordable Care Act. Under the Constitution, that judgment is reserved to the American people. So, is that activism or is that restraint? Well, it's extremely interesting, the very, very, very narrow ledge that he is walking in this decision, because at its face, you would assume that because Chief Justice John Roberts ultimately makes a decision that upholds the individual mandate and essentially saves the Affordable Care Act, that it's an example of judicial activism. And I can see where you would get that. But essentially, this is judicial restraint. He's conceding that it is not the place. It is not the place of the Supreme Court to decide on whether or not a law should be in place. It's only the responsibility of the court to make a judgment on the constitutionality of a law, which he is in fact obviously willing to do. Which means that it comes down to the big question. Can Congress use its Article I powers to make Americans buy health insurance? Can Congress force people to buy health insurance? That's what Chief Justice Roberts ultimately is going to be making a decision on, right? What is incorporated or what is included in the Commerce Clause? Does the Commerce Clause allow for the federal government to mandate the sale or the purchasing of health insurance? Obviously, Clarence Thomas is a no. Sotomayor is a yes. Scalia is a no. Breyer is a yes. Alito is a no. Kagan is a yes. Ginsburg is a yes. Kennedy is a no. And we're stuck at 4-4. We have a 4-4 split, and the decision is ultimately going to lean or to rest with Chief Justice John Roberts. And you would look at it and say the conservative in him thinks this is a dumb law, that we should not in fact have a healthcare or a health insurance system provided by the federal government. But there's a part of me that believes in judicial restraint as well. And the part of me that believes in judicial restraint says that it's not my decision. It's not my decision to create laws. If this law was written, if it was passed through Congress, if it was signed by the President of the United States, I can't simply rule it unconstitutional because I don't like it. That's not my place. My place, as somebody that appreciates judicial restraint, is to simply rule on the constitutionality of the Affordable Care Act, right? And that's where the Chief Justice gets kind of in a really tricky spot in the NFIB versus Sibelius decision. It's his conservatism versus his belief in judicial restraint. Here's a little video to refresh you for those of you that are looking for the details. And ultimately, Chief Justice Roberts makes the decision that Congress does in fact have the authority to mandate the purchase of health insurance because of their ability to tax, because of their taxing power, not as a result of the Commerce Clause, as Democrats in Congress and the President and President Obama had expected, but that no. Obamacare, the Obamacare system, the Affordable Care Act, and the system that it puts in place is in fact going to be upheld. And it really creates this weird situation. Because yes, Democrats get their health care bill. President Obama gets his health care system. But ultimately, conservatives and Republicans finally see a limit on the Commerce Clause, right? It's a really, really fine line that Chief Justice John Roberts walks on this decision. The question of judicial restraint versus judicial activism is a really big piece of the Second Amendment conversation, right? If you're a fan of judicial restraint, you look at the Second Amendment and you say very clearly right there that it's the right of the people to keep and bear arms, and that right shall not be infringed, right? And so any law passed by Congress having to do with the Second Amendment, so long as it isn't a violation of the Constitution, we're going to uphold. On the other side of that, if you're a fan of judicial activism, you're a little bit more willing to let the Supreme Court be policymaker and be contemporary and be modern with regards to what the Second Amendment means in 2020. All right, so ultimately that's all I have for you today. Again, you have a test coming later this week. If you have any questions at all, please reach out to me using email, Google Chat, whatever you need. I would be more than happy to help. I've had several students where I've set up one-on-one Google Meets and just let them fire away with questions for 10, 20 minutes at a time. Those seem to be very helpful. So if you'd like to set one of those up, please let me know. I would be more than willing to accommodate your schedule however I need to. But other than that, have a great rest of your day, and I'll see you guys tomorrow.